Hello and welcome from the Authors Guild and Authors Guild Foundation. We're here for Copyright Registration 101 with the team from RightsClick, David Newhoff and Stephen Tepp. Joining us as well is our CEO of the Authors Guild, Mary Rasenberger, and our Chief Legal Officer, Kevin Amer. Thanks to the audience and thanks for the questions you sent in. We've shared those with David and Stephen. Those will all be addressed and we'll have Q&A time at the end. You can feel free to use the Q&A box in Zoom to enter more questions at any time. And as always, thanks to the donors of the Authors Guild Foundation, whose support allows us to put on free public programming like this. You can learn more about Authors Guild member benefits like legal advice and contract reviews, as well as the advocacy work of the Authors Guild Foundation at authorsguild.org. And with that, I'll go ahead and turn it over to Mary Rasenberger. Thank you.
Hello, everybody. Thank you very much, Johnny, for that introduction. We are delighted to have with us here today David Newhoff and Stephen Tepp from RightsClick, and I will introduce them in just a minute. We are having this webinar today on registration, and we are going to have a series of them because of the importance of copyright registration. And that has come to light in particular with the Anthropic settlement, as I'm sure most of you are aware at this point, that the way that the class was defined in the Anthropic case was it only includes rights holders of books that were registered, and not just registered at any time, but registered within 3 months of publication of the book or before the infringement. Okay, that was one requirement, and also within 5 years of publication. And in a second, I'll explain why that is the case. Most trade contracts, or most publishing contracts for that matter, do say that the publisher is required to register the book for the author in the author's name. That is not true for educational texts or other books where the publisher acquires the entire copyright, but in a trade contract and most university press contracts, you, the author, keep copyright ownership and you assign to the publisher only the exclusive right to do various things in order to publish the book in the various formats or in excerpts. And you retain the rest of the copyright. But the publisher agrees to do the registration in your name. Now, what came to light through the Anthropic suit is that a lot of books were not registered or were not registered in a timely basis, and for that reason are not included in the settlement. And we've written about it. Kevin, could you put in the chat, or Johnny, if Kevin doesn't have access to the chat, a link to our blog on registration, and particularly with respect to the Anthropic lawsuit. I think we have a page on registration, and we also have a blog on registration in the Anthropic lawsuit. So I just wanted to emphasize sort of the importance of making sure you have a registration, have it timely, and also if your publisher has an obligation to register, don't just assume they will and that they will do it on time. Also, make sure, just check in, make sure it's happened, make sure that they have actually registered, because there were many instances that have come to light. One where the publisher did have an obligation to register and just didn't do it for whatever reason, or they filed the application, because we followed up in a lot of cases actually with the Copyright Office to see what was going on here. Is this your records? Is it, what happened? And we sent them some test cases. In a number of instances, the publisher failed to send the deposit copy. And I should back up and say that your registration is effective from the date a full application is filed. But to file a full application, it includes the not just the application itself, but the deposit copy. So in some cases, the publisher never followed up with the deposit copies, which still have to be for books. They still want the actual print books, because they go to the Library of Congress's collection. And And also, or in some cases, it was because there was some communication they didn't follow up. But there are many different reasons that books weren't registered on time. It also has come to our attention that many self-published authors have not registered their books. And you should know that you absolutely, absolutely need to register um, if you self-publish. And I'm gonna uh, just screen share for a minute. Just I have a few slides that we do with our basic copyright 101, but it's just to highlight a few things. And it may be that Steve and David are going to go over this too, and I apologize if that's the case, but I think it's good. Just you can't hear this enough. So um, let me just start by saying, yeah, yes, you have a copyright under the 1976 Act, which was effective as of um, January 1, 1978. You have a copyright ostensibly. Well, you do have a copyright. The law says you have a copyright from the moment of creation. However, you can't enforce that copyright without a registration. So a registration is required to bring a federal lawsuit, to bring any lawsuit, because a copyright infringement lawsuit is a federal lawsuit. Um, and there is a way to do that. I mean, people do this all the time. It's like I need to sue, and they quickly get a registration, and the Copyright Office allows you to get expedited registration in anticipation of litigation. Of course, there are times like now when the Copyright Office isn't open because the government's closed. I guess that means for people who want to bring litigation, you just got to wait till they open back up. Although maybe there's an emergency way to get one right now. I don't know. Um, but you do need to bring a registration within to get statutory damages, which means you don't need to prove actual damages. There's statutory damages in the law of between 750 and 30,000 for non-willful infringement, and they go up to 150 per work for willful infringement. That it is very hard to prove actual damages, and it's hard to find a lawyer who will take on your case honestly. It's also in the class action suits. They want to see a registration because it makes for an easier class to get certified, I will say. So it's not just that you should get a registration before you bring the lawsuit, but you really got to think about doing it within 3 months of publication. Um, it can also be before the infringement occurs, but to be safe, so it could be you don't file for a year, but the registration happens 2 years later, you're going to be okay. But you don't know when the infringement's starting, so to be on the safe side, register within 3 months of publication. And you should also be aware that registration gives you a presumption of all of the facts that are in the registration certificate. And that is really important for a class action lawsuit because judges don't want to see in a class action where you've um, every single work, the registration needs to be, the ownership needs to be proved, right? So the thing about within 5 years of publication, the owner, the fact of that it's copyrightable, all of those facts are deemed presumed, and it would be up to the infringer, the defendant, to prove otherwise. So hugely important. I also wanted to mention, and again, Stephen, David, apologies if you guys were going to go over this, but it's something I want to emphasize for authors because we haven't done that before. You can register your work before publication. The Copyright Office has a rule that you can't register your work, any work twice, except that you can register pre-publication and post-publication. So if you are concerned about it, you definitely can register before you even send your manuscript out, and that ensures that the work itself has been registered. And I'm not going to go over this because I'm sure David and Steve will, like how you register. I will just say that it is relatively simple. Um, and particularly for books, because you can, for if there's only one author, you can use the simple application, which is only for $45. And I also want to mention that there is a group registration for short text works that we and other author groups were very involved in getting it established just a few years ago. And that is for short online literary works of between 50 and 7,500 words, any that are published within a 3-month period. You can file those together. So if you're a blogger, you've got a Substack, you do a lot of journalism, just be aware that that's available too. And I think I will stop there and just know that the Authors Guild can help you register your works. If you're trying to do it on your own, just file a legal request. You have to be a member to get legal services, of course. And then there are services like RightsClick, which does an amazing, it makes it really, really easy, and I'll let them explain it. But it is a great service. It is very affordable, allows you to register easily, and also to keep track of and enforce your work. So without any further ado, let me introduce our panelists. They, as I said, they are both well-known and very distinguished copyright advocates. David Newhoff, building on his background in film production and communications, is a widely respected advocate of creators' rights. He has written over 1,000 articles on his blog, The Illusion of More, which is one of the most respected blogs on copyright out there, and I recommend it highly to everyone. It's Illusion of More. And he endorses strong copyright rights and questions the tech industry's assaults on those rights. He's a very much a strong advocate and ally of authors. He's been cited by the Copyright Office, the press, and the creative community, and he published a book, Who Invented Oscar Wilde, the photograph at the center of the modern American copyright, which I also highly recommend. Steve Tepp has extensive background in IP law and policy. He began as an attorney for the Senate Judiciary Committee, and then he served as senior counsel, excuse me, for policy and international affairs at the Copyright Office, where Steve and I actually overlapped for several years there. And then he was Chief Intellectual Property Counsel for the Global Intellectual Property Center of the U.S. Chamber of Commerce, which is a very powerful group within the copyright industry, and really do a lot to help ensure that we have enforceable and strong IP protection in this country. And before co-founding RightsClick with David, he started the IP consultancy Sentinel Worldwide and taught copyright law at George Washington University Law School. So let me turn it over to you guys, and thank you again for coming today.
Thank you so much, Mary. Excuse me. You did a great job covering some of the most important basics of copyright and copyright registration. So I'm going to try and speed through some of this material and address some of the questions Johnny has already passed along to us,
Great.
as well as some of the new questions that are coming into the chat, which we're going to try and keep up with, but there's a lot. We'll do our best. So understanding that there's a wide range of background knowledge, just some very quick basics about copyright law. The term of protection for any work created after January 1st, 1978 is the life of the author plus another 70 years, unless it's a work for hire or an anonymous or pseudonymous work. We can talk about those because that in that case, you don't have a human author to base the life calculation on. When you get copyright, it is technically automatic, and we'll talk about that in a minute. You get what's called a bundle of rights. And these are rights to authorize or prohibit people from engaging in reproduction of your work, literally the copyright, creating derivative works, that's an adaptation that includes books being made into movies, translation of books, sequels, and so on. Distribution, which means providing people with physical copies. Like, it can be a digital, that's considered a physical copy. But any instance where someone else is obtaining ownership of a copy of the work, that's a distribution. Public performance doesn't really apply here. That's what we talk about when we're talking about movies and music, where someone's making a performance. Technically, if you're at a book reading, that's a performance of a book, but much more common is going to be public display, where someone is showing your book cover. So it can hit both, but the performing arts is what we think of with public performance. So if the book's made into a movie and so on. And then performance by digital transmission is just for music, so we don't need to talk about that. All right, David, can we go to the next one? Thanks. Okay, as Mary said, as you know, the Anthropic settlement has highlighted the importance of registration in the US copyright system. And in fact, even before the Anthropic settlement, there was another AI class action by authors where 2 of the 3 named authors were thrown out of the suit because they hadn't registered their works. So cannot emphasize enough. Mary said it a bunch of times. I'm going to add to it. David's going to add to it. You've got to register to protect your work in the United States, because copyright is automatic, but the catch is you can't enforce your rights and at all or effectively without registration. Let me take a moment. We got a lot of questions about publication outside the United States, non-US authors trying to enforce their rights outside the United States, inside the United States. Here's how it works. If you are a US author, you cannot go to court at all unless you've registered your work with the Copyright Office first. And only the US Copyright Office opens that door for you. No other form of registration, no form of emailing it to yourself, mailing it to yourself, none of that works. If you file a lawsuit for a work in the United States that you haven't registered, your lawsuit will be dismissed instantly. You're done. You must register. That's only for US authors. Foreign authors don't have that requirement because of treaty obligations. We won't spend any time getting into that, but that's why. However, non-US works are subject to the registration requirement in order to get all the other enforcement benefits. The presumption of evidence, that's a 5-year window. You must register your work within 5 years of first publication in order for the presumption of ownership and authorship and the presumption that the work is copyrightable to have its full effect in US courts, whether you're a foreign author enforcing here or a US author enforcing here. Statutory damages and attorney's fees, Mary already talked about those. Those have to be filed. The registration has to be either prior to publication or within 3 months of first publication, or if you miss that window, it's still worth sending in a registration application, because any registration that has an effective date prior to the commencement of an infringement, you can get statutory damages. Even if it's 10 years down the road, you can register anytime in the life of the copyright, your life and 70 more years. Your grandkids could, in theory, be registering your work if you didn't do it. However, you've got to register before an infringement takes place if you miss that 3-month window after first publication. So if you found you got infringed, but you hadn't registered, you're not going to get statutory damages against that defendant, but against the next defendant, you will. And another key point here, most copyright infringement cases never go to court, and they certainly never go to trial. A few do, of course. More often they settle. And having a registration in hand that's prior to the infringement in question gives you a very strong hand. I like to use the analogy, it's like playing poker with a pair of aces showing. You're holding a strong hand, they can see it, and you're much more likely to get a settlement and a quick settlement. Does US copyright registration have effect outside the United States? Not formally, although I've seen other countries' courts give it some credence. They're not required to. Do foreign registrations have any effect in the United States? Emphatically, no. Most countries don't even have a registration system. The US, to my knowledge, is the only country that has a registration system that has substantive requirements, benefits that you don't get if you haven't used it. Other countries that have a registration system, it's entirely voluntary and very few people use it. All right, David, over to you.
So I know Mary already talked about this, but we did want to emphasize this because it comes up a lot. Who's responsible for registration? And like a lot of you, for my one book that I've published so far, I signed a standard trade contract, and it was right there in the contract that the publisher was required or supposed to register the work, concurrent with or shortly after publication. I was a pain in the neck about it because I know copyright law, so I kept bothering the publisher. Did you get this done? And there was a point at which my literary agent actually said, "Well, if he doesn't get it done, do it yourself." And that's kind of the question that has resonated after the whole Anthropic deal, because of course, if I hadn't known, I would have just assumed they were going to do it. And would have been very surprised to learn later that they hadn't. So by all means, if you're unsure, definitely check your contract, see who is responsible for it, and even if it's the publisher, do make sure that they've done it. And if they don't take care of it, then you have to decide how much you're gonna, bother them to make sure they get it done, or just get it done yourself, because it's well worth making sure you're registered for all the reasons that have been presented. What are some basics when it comes to registration if you were to do it yourself? Again, some of this is duplicative of what Mary covered, but the basic requirements for any registration with the Copyright Office is the application form, the fee, and the deposit copy. There's two considerations, especially with books, when it comes to deposit copies. There's an electronic copy, which will always go with a registration if you're filing online. You'll have a PDF or a Word document or some other document that's allowable by the office that'll have the finished work. And then, of course, there's sometimes already a physical book. The rule is that if the work was first published in physical form, then the office/library really requires 2 physical copies be sent in. It's not a super complicated process. You can still file electronically, and then at the end of the process, there's a place to get the form. It's a shipping form that has a barcode associated with the application. You send in the copies of the book, or alternatively, the publisher would be doing this. Again, this is a question of whose responsibility it is, but that's the basic step. And where you do this is at copyright.gov, and then you follow the links to the registration portal. You would go in. I know Mary mentioned the group registration. I'll come back to that in a moment. There's 2 forms you're likely to use. One is $45, the other $65. That being the simplest form is the one work by one author, and that's the cheapest form and the most basic. But you also want to read the rules very carefully. The office is kind of unforgiving, as we've seen, if you use the one work by one author form and you're not meeting the criteria, because there are some restrictions to what kind of work can be registered that way. Hence the standard application, which has a little bit more elasticity. It asks some other questions that are not in the one work by one author. It of course includes a joint authorship option, And another topic that we're going to talk about in a moment, limit of claim, which can come up quite often. If you looked at the two forms, the limit of claim in the standard application is really simple because it's a checkbox. And you don't have to worry about any details. You just kind of check column A and column B, and we'll come to that in a moment. And finally, turnaround time comes up a lot, notwithstanding the office being closed right now. When the office is functioning and staffed, the turnaround time on single work applications tends to be as fast as a couple of weeks, maybe as long as 3 months. But that's 3 months before it's processed and the certificate is mailed, usually to you, or if you want it mailed to an agent or an attorney or somebody, that's your choice. But that's roughly how long it takes for them to process applications. But again, as I'm pretty sure both Steve and Mary probably said already, the effective date of registration is the day the office receives your application. And that is key because if you send in an application and somebody infringes your work the next day, that's the effect that you're effectively covered. The only caveats there are: one, you do have to have received the certificate before you can proceed with legal action. The court will want that certificate. And two, if for some reason the office turns down the registration, then you've got a time lag issue. Rejections of registrations are not super common. Sometimes there are questions the examiner wants to know. You've answered something in a way that doesn't make sense to them. There's some material in there they have a question about, but rejections are just not super common, particularly for literary works. Our friends in the design world have a little harder time sometimes. And then I will turn back over to Steve for these topics.
Thanks, David. I was answering in the Q&A, so let me jump back here. Okay, when to register. So okay. Sorry. The best case scenario is register before the work leaves your hands. That way you are certain that it's registered before anyone has an opportunity to infringe it. Now, if your publisher is committed to performing the registration, as we've learned, not all publishers can be counted on to do that. So you've got to stay on them to make sure it happens. If you're sending your work into some sort of contest, make sure you register before you send it, because you don't know who's going to have access to it in the course of that contest. What if the work is published and you haven't registered, you have 3 months, that 90-day window is what the law says, to register and still have full protection. Even if you miss that, it's always worth registering, because okay, the infringements that happened before you registered, if you miss all those windows, are not covered. But once you've registered, you've got your full scope of remedies going forward against anyone in the United States who infringes your work. Effective date. The effective date of registration, Mary covered this, but I'm going to say it again because it's super important. The effective date of registration is not the day you get your certificate from the Copyright Office. It's the day that you submit a complete application to the Copyright Office. A complete application is filling out the form or online, completing all the questions, paying the fee, and sending the required copies of the works. Right now, the Copyright Office is closed because of the government shutdown, but their online system is still accepting applications. And by sending in your applications now, you are establishing an effective date of registration. Depending on how long the shutdown lasts and how much of a backlog gets created, you may not see your registration certificate for 4 or 5 months. Who knows? Doesn't matter for purposes of your effective date of registration. If you send it in today, today will be your effective date of registration. The only reason it will matter.
Yeah, can I just jump in? Because I think, correct me if I'm wrong, but books still, if a book is published in print form, the Copyright Office, collects deposits for the Library of Congress, and they want the print copy. They want the best edition, which in most cases is the hard copy. So, and you don't have a complete application until you have sent in that deposit copy too.
You took the words out of my mouth.
Oh, sorry. Yeah.
No, it's all
Want to make
good.
sure
It's all good.
that's, yeah,
So
because
no, let me
that's one of the things that hasn't happened in a lot of cases. Yeah.
let me distinguish to be very specific, because I know there's a lot of different instances, people have different situations. If your work was first published, the first time it was published was only in electronic format, you can just upload a PDF to the Copyright Office website and you're done. Simple. However, what Mary just said is if your work was first published either in both electronic and physical format, or first published only in physical hard copy format, then yes, the Copyright Office wants you to mail in 2 copies of the hard copy of the work, and your effective date of registration is not established until they receive that in their mailroom and stamp it into the system. So that's an additional complication during the shutdown. For what it's worth, if you use RightsClick, we submit all the information, the forms, complete the forms online, and then the Copyright Office system generates mailing labels. We'll send those to you so you can then just put those on the works and send them in. When to register new versions of your work? Question we get all the time. Technically, a new version is, in the copyright laws, considered a derivative of a prior version. If you have not ever registered or published your work, you don't need to worry about older versions. Just register the version that's going to go public, going to be published or has been published. If a prior version was either published or registered, then you have to consider how much has been changed, because a registration of a new version of a work that's previously been published or registered will only cover the new expression, the new authorship since that prior publication or registration. And if there isn't that big a difference, then really there's not that much of a need, because your old registration of the prior version covers most of the material that's also in the new version. All right, I think that's everything for this slide, David, if you don't mind. Okay, limit of claim. This is an important part of copyright registration applications that can sometimes trip people up. You have to tell the Copyright Office if there's anything in what you're sending them that isn't your authorship. And it's your new authorship. So when I just talked about new versions, if you had a version of your work that was published or registered, and then you made really big changes and you want to register the new version, you have to tell the Copyright Office, I'm limiting my claim to just this new authorship. The old authorship from the version that was previously registered, for example, is not covered, because that would be covered under the previous registration. You don't have to go through and say, oh, I made changes in chapter 7, or nothing even close to that. As you can see kind of on this slide, it's a little small. All you have to do is click old material, claim, click text, new material, also text. You're done. That's it. They just need to know that there is some material and what kind of material it is. Likewise, if you had a book with illustrations or photographs that weren't your authorship, you need to disclaim those because they're not your authorship. You don't have to go through item by item and say, okay, the chart on page 72. No, just photographs, and you're done. Same thing with AI. If you've used AI to generate, let's say, images, not your authorship, just disclaim those images, and you can hit other for anything that's not on their list. Now, we're also aware that everyone, all creators, are using AI to create a first version of a work, and then they're making changes to it. In that case, you'd have to disclaim that there's text that was created by AI and text that was created by you, and you may need a bit longer of an explanation to show exactly what you, or not exactly, but in general, what authorship you've added, because the Copyright Office has said purely AI generated material is not copyrightable and they won't register it. So you have to show what human authorship has been added to what started as AI authorship. All right, David, back over to you.
Sure. So I just wanted to, before going to RightsClick a little bit, re-emphasize. I saw a lot of questions in the chat about, and this comes up a lot for authors, is when to register. Either the first time, because I'm about to send out, my manuscript to prospective publishers or agents. Do I do it then? And also same thing, at what point do I re-register or register rather a new version of something? Very much a judgment call. There is no bright line on that. It can be really tough because of course, you don't want to register over and over again, and you don't want to spend money you don't need to spend per se. But but you also want to be protected. So, and it's only natural, right? If you have a manuscript you're sending out to agents and whatnot, and the likelihood that it's going to change somewhat is pretty high. As Mary says, that can be cured by the fact that you might register the electronic version and then also subsequently register the physical print version as well. As far as when to register something new, again, it's really a question of, did you change it dramatically? Did you change it substantially? Just yesterday, my brother-in-law said, "Oh, I registered plays, but I changed the title of the play. Should I change should I do the registration again?" Well, titles aren't protected. Small changes aren't necessarily going to be a big factor when it comes to a new registration. If you've made wholesale changes, written a brand new chapter, then I would do personally what Steve just described is, here's the new manuscript, here's the text. I'm disclaiming some text, that I've already registered, and I'm just going to claim new text that I am registering. And that's sufficient for registration process. The details would only come to light if you actually are in a litigation where it's like, okay, show us the new chapter that you registered in a timely fashion. Anyway, I hope that helps more than it hurts. But suffice to say, as mentioned, you can do this by going to the Copyright Office website yourself. Some people find it onerous, and some people find it less onerous. Certainly, the instructions are no fun, I think, even for attorneys to read at times. And the Copyright Office has a disturbing relationship with the color red that it uses for things that are actually not bad. It puts things up in red text that always scare me, and I see it every day. Anyway, we created recently a new portal on our website just for Authors Guild members, where we will process registration applications. We've streamlined the forms. There's two that one would track toward to the single work form, the other to the standard, depending on the circumstances. And we've streamlined everything down to one form. As you see, we charge a processing fee. We also do provide support and help, with the exception that we cannot provide legal advice. Members can get legal advice certainly from Authors Guild and from their own attorneys. We are not allowed to do that, but we can give you administrative information and tell you what the law says. So we've done things like, our form looks somewhat like this. It's just one page. You'd enter everything one time and then send it off. And we would then, what we do is when we process it and then send you back a confirmation with a case number and your application form attached, and then you've got that and can track that. And then the next thing, the office would typically, again, once they're open, send you your certificate. We also have the full RightsClick suite that we won't demo today. but it's got a lot more going on in there. And for instance, Mary mentioned that you can register, for example, a group of works. We'll support, for example, in here, a group of unpublished works. So maybe you've got 10 unpublished short stories. You can register all of those on a single application. We don't support that kind of registration via the web portal, but we do it within the RightsClick suite. We also have some other tools in there. And again, for members of groups like Authors Guild, we offer a lower rate, a 3-month free trial, and a rate of $5.95 a month. And that's the coupon code that you would use if you want to sign up. You can certainly, depending on what kind of writer you are, it may be a way to go. And you can certainly try it out for 3 months and see if it's for you. And we always are happy to answer questions along the way. That covers the RightsClick stuff, but I am sure there are at least somewhere between 10 and 50 questions that we want to answer live. So perhaps.
So I just saw one that I think we should answer live in the chat. There are a lot of great questions. So thanks everyone in the audience for your very good questions. Pseudonyms, and I'm sorry, I've been working on the Q&A, so if you did answer that already, apologies. But can you talk about how to register pseudonyms?
Sure. Shall I, Steve?
Go for it.
So you'll see if you go into the rights, even on our form or in the office, they do ask the pseudonym question. The important distinction, though, is do you want to register the work as a pseudonymous work, which actually changes the term of protection a little bit, or do you want to tell the office to register it in your natural name, but a pseudonym appears on the work? And those are two different forms. The instruction, or same form, excuse me. The instructions are a little bit different. So in one, you would simply say, you wouldn't select pseudonym, let's say, and you want to register it as, if I want to register it as David, I'd leave all that alone. And then in the examiner notes, I would say, the author's pseudonym appears on this work, and I would put in the name of the pseudonym. Alternatively, if you register the work as a pseudonymous work, then it is protected for 95 years from the date of publication, right, attorneys? Which is a little different than life of the author plus 70. Probably. They're both long registrations, but it is the only distinction from a registration standpoint.
Yeah, thank you for that. I think, what's come to light in the Anthropic settlement is that it's just, if somebody registered with in their own name and didn't put the pseudonym in the registration, sometimes it hasn't been, might not be properly matched up. So unless you want to remain anonymous for any reason, we suggest putting your real legal name in. We understand there are cases where you want a pseudonym because you want to remain anonymous, or you can also register anonymously. And in those cases, we get it. You do have the term of 95 years, though, instead of life plus 70. And depending how old you are, that may or may not make a big difference. But just it's always good if you can to make sure you've got the pseudonym and your real name in the application, which becomes the registration certificate, that information.
If it were me, I would always go with that option of registering in my natural name and then telling the office pseudonym appears on the book.
Yeah. Because in the lawsuits, they're getting the pseudonym is the name on the book, right? So there has to be a way to match it up. But again, that's only important for these big class actions, which hope we may be seeing a lot of them in the future, just as tech companies and AI companies just trample over our rights. I will say the class action mechanism is the one way that authors can fight back, and it's a really important legal process to do so.
I see a bunch of questions in the chat about Copyright Office fees. So I just want to reiterate those. For us, the Copyright Office has a few different forms, and there are different fees depending on the form you use. The simplest form is called the single work, single author application. That's $45 Copyright Office fee. The standard application is $65 Copyright Office fee. Now you may be saying, well, then I'm going to use the $45 one, right? But you've got to be really careful because the Copyright Office has very strict rules about the single work form. So for example, if your book has one photograph by somebody else and you disclaim that and you use the single work form, you're going to get rejected because they're going to say, oh no, there's another work in there that wasn't yours. That's two works, not one. You use the wrong form, you're rejected, you lose your fee, it's not refundable, you lose your effective date of application, you've got to refile with a standard application and pay the $65 fee and start all over. So you've got to be careful with that. And RightsClick, just so you know, guides you to the correct form based on the information you put into the system. We have a landing page specifically for Authors Guild members with a discount. It's only a $25 processing fee, $24.95 for the RightsClick processing fee. On, of course, that's on top of the Copyright Office fees, which we just have to pass along.
Which is a great deal. It's an amazing deal. If I could.
No one else is anywhere near that.
Yeah.
I think the next closest is $100. So it, when you consider the value of registering your work, that you could get thousands of dollars more or miss out on an infringement, the ability to enforce an infringement entirely, $24.95 plus Copyright Office fees is not that bad. And our system is set up to guide you to the right form so you don't have that trouble. The copyright, some people use the Copyright Office system, and it's not impossible to use it, but you have to know what you're doing. You have to pick the right form. You have to have an account or enter your credit card information. You got to deal with the fact that it's, according to the Copyright Office's own count, it's 28 screens to be able to send in one copyright application as opposed to one screen on RightsClick. So look, if you know how to do it and you're good, go for it. If you want to save yourself some time, that's why RightsClick is here.
Yeah, thank you. There's a couple things that I do want to clarify. One is there are some questions about ISBNs and registering with the Library of Congress, the LCCN number. And I know this is confusing. There are a lot of different numbers for books. So I'm just happen to have a Jody Cole book next to me. You will see, on the copyright page, there's going to have, a copyright notice. You won't see the registration number, the copyright registration number, though, usually in a book. You will have an ISBN number and an LCCN number. So the ISBN number is something that you get in the US. Bowker is the exclusive agent to issue ISBN numbers. That is a number that you need to distribute your book through most channels. I think every channel other than Amazon requires an ISBN number. Amazon requires what's called an ASIN number, ASIN. It's their own numbering system, okay? That is completely separate from copyright and copyright registration. Separately, you can record your book with the Library of Congress's system, which gives you a catalog, a kind of cataloging number, and that is your LCCN number. That is not your copyright number, okay? That just it enables gives you a, and I'm not saying this right, so somebody who's a librarian needs to correct me, but it is for cataloging purposes. It is not for copyright registration. So I just want to make sure that's clear, because that can be confusing. And in my 11 years at the Authors Guild, I will tell you that I've seen many authors confuse Library of Congress, getting a catalog registration with copyright registration, since the Copyright Office is in the Library of Congress. So I just want to make sure that everyone understands that's separate. there are also a lot of questions about, sort of what do I do if I'm based overseas? Foreign, only, it was already said, only the US requires registration for bringing lawsuits and for enforcement, essentially. Because I think, as David, as you said earlier, it's hard to even enforce your mark without bringing a lawsuit if you don't have a registration, because the defendant may not take you seriously. So we recommend it for that too. But so maybe we can talk a little bit more about that. You don't need a registration, as David said, if you are not a U.S. national to bring a lawsuit. However, as we've seen in the Anthropic case, you may not be included in class action agreements. And that is because for class action, for the class to be certified, all of the participants in the class need to have they need to have essentially the same types of claims, the same types of harm. You don't want a class action where every single member of the class has to separately prove things like ownership and damages. And so for that reason, class action attorneys want to rely on statutory damages, right? So, and again, you don't get those if you're not registered on a timely basis. So you're likely not to be included in these US class actions if you don't have a registration. About the Anthropic suit, we said a little bit at the beginning, but there are a few questions about that. Can I still be included? The answer is no. Um, the requirements for being included in that class, in addition to having the timely registration, you have to have an ISBN number, but your book has to have been actually downloaded by Anthropic from LibGen or PLE, the pirate library site. And Mirror, it's Pirate Library Mirror is what it stands for. It was also Z Library and Anna's Archive of different iterations. But those downloads occurred in the summer of 21 and 22 respectively. So your book would have had to have been on those pirate sites at that time and would have had to have been downloaded then. So uh, and in addition, Judge Alsup wanted a final list in September. And so if your book, and I consider that an additional requirement because, like, I don't know, who knows if books were left off the list by error, but that is a final list. So to find out whether or not your books are included in the Anthropic settlement, you need to go to the settlement website. I'm going to ask Kevin or Johnny to put a link to that in the chat. Um, and there is a works list there. Search for your work. Search by author, title, in any way that you can if it doesn't come up right away. But if your book's not on that list, you're not included in the lawsuit, unfortunately. And I'm sure there are do you guys have anything to add to the foreign or any of these? There are tons of other questions that we haven't gotten to yet.
Yeah,
We're getting a lot of,
go ahead.
I see a lot of questions about cover art and whether or not that excludes people from the single work application. So let me try to address that quickly. The Copyright Office considers the work that you are submitting to be whatever you send as the deposit copy. So like we talked about earlier, if your work was first published in only electronic format, you can send a PDF. And so you can send a copy without the cover art. You just send the PDF of the text of your book, and you don't have to worry about the cover art. Your cover art won't be registered, but if it wasn't yours anyway, that's probably not your concern. If your book was first published in hard copy or both electronic and hard copy, then the Copyright Office requires hard copies and they're going to see the cover art. And if that cover art isn't yours, then yes, you have to disclaim it. And yes, that takes you out of the single work and puts you into the standard application for 20, which is $65 instead of 45.
Yes. But I should say, in most cases, look at your contract, but if you have a traditional publisher and they hired somebody to do the artwork, they usually, almost always, they retain ownership of that artwork. So unless you had the artwork done yourself, if you're a self-published author, presumably you did and you own unless you didn't acquire the rights from the artist. And we always recommend doing so, like actually getting the artist of the cover art to assign the rights to you. So usually as a self-published author, you will own the cover art. You should. As a traditionally published author, you generally do not, unless you made a special accommodation. Somebody was saying, what about quotes? Just fair use quotes in a book. I mean, typically those are not disclaimed. What do you guys think about that? I mean, just as a matter of practice, I don't.
Yeah. So, I mean, I wrote one nonfiction book. It's got lots of quotes in it. Okay, granted, many of them are written by founding fathers, so they no longer have a claim. But yeah, I think the answer, and Steve, correct me if I'm wrong, is are you quoting an appreciable amount of material from somebody else? And how much is an appreciable amount? It's slightly more than a modicum, I guess. It's it's a judgment call. It's not going to be a harm if you say I'm disclaiming some text in here that I didn't create, but it's also not necessarily going to be fraudulent if you have a handful of quotes in, say, a nonfiction book that you didn't disclaim per se.
Yeah,
Yeah, I
it's
would
a,
agree,
I can say
especially
a
if they're
lot.
in quotation marks and it's clear that they're quotes. Yeah.
it's
Sure.
a judgment call is exactly the right answer.
Mhm.
If you've got really long quotes, that's more likely to be disclaimed because, as we know under Copyright Office regulations, short phrases are per se not copyrightable. So there is not another copyright owner for a short phrase because no one holds a copyright in a short phrase. So if you've got long quotes, if you've got a lot of long quotes, then you probably want to think more seriously about disclaiming those. If you've got just a few, if they're shorter, then it's less important. But it's not a bright line rule that the Copyright Office has set out. So the best we can do is tell you it's a judgment call.
Right. And what we always remind people, and this is even though the Unicolors case was mostly a question of publication versus non-publication, the takeaway from that is that the Supreme Court said that an innocent error of law, especially by an author doing the registration, is not a basis for invalidating a registration application. And that's really the question. Have you lied to the office such that you're going to invalidate your registration? It is about a good faith effort.
Yeah. Well, with the single work, there's also a risk of your application getting rejected if the examiner decides you should have disclaimed what you didn't. And what we're talking about there goes, Mary quoted the question about fair use quotes. It's the same thing for quotes or material you use with permission. Same
Yeah,
thing for
right.
quotes you use that are public domain. If you didn't have permission and you use somebody else's material, then you're risking an infringement of somebody else's work. So we hope you're not doing that, not in a substantial way that's not fair use, of course. But it's the same answer for all of those. Whether or not the use of the material constitutes infringement, we hope not, whether it's public domain, permission, or fair use. But then whether to disclaim that is yet another question. That's
Right.
just going to be a judgment call.
And you can just disclaim some text, but if you're disclaiming like quotes or somebody said there's public domain poetry, I would, write that in public domain to poetry or quotation so that it's clear that the rest of the text is yours.
Right.
I think that's helpful. There's a few questions also about, there was a mistake in the registration or ownership has changed. There are a few questions about, the rights have reverted to me. So when a publisher, under a normal trade agreement, when the publisher registers for you, they register in your name. You are the claimant and the copyright owner. So when rights revert to you, you don't need to do anything. It's the registration is already correct. They're just doing it on your behalf. But if ownership changes or there are mistakes, okay, there are two different processes, and I'm going to ask Steve and David to help me with this because I haven't done these in a while, but there is, you can amend a registration, and that form is called a CA form, and it has its own fee with it. You do have to pay an additional fee, and they will update and correct the registration based on that. A change of ownership technically is done through recordation, which is a separate process. If you go to the Copyright Office website, you'll see that there's like a registration portal and there's a recordation portal. And changes in ownership are recorded. Now, they don't have to be. The reason to do that is if you want to make sure, you've got the chain of title is correct in the Copyright Office, or, you want to make sure someone can find you.
Right. So the corrections are for limited purposes. The Copyright Office has rules about everything, including when you can use, they call it a supplementary registration. That's the terminology they use, even though what you're doing is trying to correct something. That's probably only important if, when you typed in your address in the application, you transposed the digits or something like that. And now all the contact information is going to the wrong place. But this is really great that you brought this up, Mary, because I also saw a lot of questions like, if the work was unpublished when I registered it and now it's published, do you have to update that? Or if it was sold, you do not have to register to update a registration. The registration protects the material that's copyrightable in the deposit copy you sent to the Copyright Office. The contact information is useful so that if anyone wants to ask you for permission to use it, they know where to find you. If you sell your copyright in a work to somebody else, let them record the transfer. Why do you need to bother spending $100 or whatever the fee is for that to record somebody else's rights? Let them deal with that. If you buy somebody's book, copyright in somebody's book, then you want to record it. So that's, again, as Mary said, recordation is a different process from registration. It has totally different meaning in the law. And honestly, that's a good topic for another day because registration is complicated enough as it is. Finally, I saw some questions about RightsClick and, is it worth a subscription to RightsClick if you only have written a couple of books? Candidly, no. The RightsClick suite, if you want to subscribe, gives you access to all our enforcement tools, helps you assess, for example, the strength of an infringement claim if you find someone using your work without permission. It keeps an ongoing record of all your works and all the relevant copyright information, including the registration information. So years down the road, if you find an infringement, you know the registration number that goes with your work. But if you've only got one or two, that's why we have on our website these pages, single pages where you can just submit your registration and be done, right? Get your work registered. The registration certificate will be sent to you or to whomever else you designate. It does not come to us. It goes to you and you keep the records. And in both cases, whether it's the single application online or if you want to subscribe to the RightsClick suite, Authors Guild members have a discount. But we've also seen some questions. Not everyone here is an Authors Guild member. First of all, consider joining. Authors Guild is great. But RightsClick is available to the general public. You just don't get the Authors Guild discount if you're not an Authors Guild member.
Thank you. And can you put a link? I know it was on your slide presentation. By the way, is it okay with you guys if we send out your PowerPoint to registrants?
Of course.
Okay, great. And let's put in the chat, a link to your website and if possible, yeah, okay. With, with the page where it's the link for members. I just want to answer one more set of questions, if that's okay. I know we're a little over because I've seen a lot of questions and confusion in the Q&A about this. And part of it may have come out of the Anthropic lawsuit because we saw that there were, in some cases, people found there were a number of different registrations for their book. Like in some cases, there's none, and then others, there's multiple. So just to be really clear, the Copyright Office only wants one registration per work. The work is the text, unless it's also the artwork too, but it's not the edition, right? So whether it's ebook or print, it's the same text. You don't need to register those separately. The one exception for run registration per work is published and unpublished. They will take an unpublished version and register that, and then also register the published, even if they're the same. So that's the one exception to run one registration per work. Now, the other, I guess it's not really exception, but if there is new material, and I know David and Steve talked about this, if there's new material added, as David explained, if it's enough, you just, you need to make a judgment call, you can register a new edition. So that is why you see publishers register new editions of books. This is typical for textbooks or if there's a new introduction to a trade book, but there's no need to register each new, you need a different ISBN for each format. You do not for copyright. It is format neutral. It's about the content itself. So I just wanted to make sure that's clear to everybody. Okay, and we've got the RightsClick information, so everybody take that down. It is a really easy way, as we said, to register your work and then keep track of your registrations. And we appreciate the discount for Authors Guild members.
Of course.
May I pose one other question that I don't think was covered about registering as an LLC? Because I think some people are interested in that for the anonymity, but I'm not sure if that's the 95
Okay.
years or life plus 70.
Let me answer that because I feel very strongly about this, and I did answer it in the Q&A. Ownership, we want authors to register yourself as the author, okay? There are tax attorneys, accountants who will tell you to put everything, work as all of your books should be owned by your LLC. Well, okay, that's okay if you, as long as you are the claimant, you put yourself as the author, you can assign the rights to the LLC and then and register them as the owner, I guess, but you need to be the author. And you do not want to be writing books for your LLC on a work made for hire basis. And here's why. This is a separate webinar that we're going to do probably in the next couple months, but you could possibly lose your rights to termination. And that is a termination provision in the Copyright Act that allows you to terminate any transfer of rights, any license, any assignment 35 to 40 years after the grant. If you're not the author, you can't do it. And the law right now isn't that clear about whether if you're using a loan out corporation, you're still considered the author. So we highly recommend that when you register, you are the claimant, you are the author, and then after that your LLC doesn't take ownership until after creation, and then you as the author assign the rights to the LLC. I don't know if I said that clearly. It's probably a little confusing, but you want to make sure that you, however the work is registered, that you are the author and that you are not working for your LLC on a work made for hire basis.
I'll add very quickly that RightsClick can accommodate both. If you're registering as the LLC as the author, you can't use the single work because it's the single author work. You've got to use the standard application, which is $20 more. If the concern is privacy, if that's all you're worried about, there are a few ways to protect that. One, You don't have to give a phone number, that's optional. 2, you do have to give an email, but you can create a new email for free just for this purpose, as long as you monitor it. And even your address can be a PO box. If you're, there's a little bit of expense for that, of course, but if you don't want your address published as part of the Copyright Office records, you can provide a PO box. And again, RightsClick helps you with all of that.
Yeah, that's really helpful, Steve. Thanks. Yeah. Okay, good question. There's so many great questions.
You could keep
Any
going.
final
I'll only-
words? Yeah.
I'll only add, there's so many great and actually detailed questions that A, we wouldn't have time to get to. I apologize. And also B, as an AG member, I encourage you to reach out to AG Legal with some of these questions, because they are very specific, and I advise getting advice on them.
Yeah, and I did try to, I'm sure I didn't, there's still a lot that we didn't get to. If you have, I did respond to a couple people like, I can't possibly answer this question based on what you've told us for something really specific, if you're a member, just, go to the website, and Johnny, maybe can you put in the link to legal help requests? Really easy online to get to sign up to get legal help. And if you're not a member, costs $149 per year. It's really, it's like the cheapest, absolutely cheapest legal services out there. Now, we're not a full function legal services team, but we provide, contract reviews, just and advice on questions about IP and lawsuits, and if your publisher's not paying you, any complaints you have that are specifically related to your authorship career, we can help you out. Okay, well, thank you guys very, very much. And we will be sending out, Johnny will send out materials later, and we'll go through the Q&A and see if there's anything else we need to respond to.
Thank you so much, Mary.
Thank you very much. Thank you all.
Thank you,
Kevin,
guys.
Johnny, great to talk to you all. We are passionate about authors' rights, and that's why we founded RightsClick. So we hope you'll pop on over to rightsclick.com. You can send us Q&A there as well. And we can't give legal counsel, but we're happy to help you understand the law. And our system is designed to make everything as smooth and easy as possible.
Thank you again. Thanks for everyone
Thank you.
Guys.
who joined, and to the Authors Guild.
Have a great rest of your week.